Hello and welcome. I'm Peter Afrasiabi. I'm a partner at 1LP, and welcome to this episode of The Curious Lawyer. Today, you, the curious lawyer, will learn about presidential pardons, everything you ever wanted to know. We're going to cover Nixon, Hoffa, Iran-Contra, Wikileaks, and self-pardons too. So sit back and enjoy this fun, light walk through a unique, different area of law that you may not have been exposed to, the law of presidential pardons. The first slide sets the stage for the different legal issues that we are going to be exploring and discussing and learning about today. We'll start with the constitutional authority, that is the presidential pardon power, the difference between the pardon power and the commutation power with respect to sentences, the really broad, awesome, in some sense, scope of this power, the nature of whether the power extends to historical crimes and or is it future preemptive immunity too. We will look at a set of famed historical cases that we can pick to go through just to talk about the pardon power and how it works, including President Nixon, some Iran-Contra, Jimmy Hoffa, and some other such cases. We will also explore the issue that's been largely debated by legal academics in the news as of late, as of late being 2017, 2018, and that is the presidential power to pardon him or herself. We'll look at posthumous pardons, and then also the administrative process that you as a lawyer, if you have a client who wants to seek a pardon and do the pardon application process, the entire administrative gamut and legal regulatory regime that you actually do have to confront, because there actually is a detailed regulatory regime. Let's start then on the first slide here, which is the legal framework, the United States Constitution. Article 2, Section 2, Clause 1 of the Constitution is the Pardon Clause, and it says that the President, quote, shall have power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment. This is, without a doubt, one of the broadest presidential powers not subject to any congressional legislation, any congressional limitation, any congressional clawback. It really is that one of those rare places where the executive has complete power without the need to check with other branches of government on the exercise of that power, and without oversight, really, from other branches of government, subject, of course, to the except in cases of impeachment limitation. Before we dive into the Pardon Power Clause, let's take a look at the historical basis for the very idea of pardoning and the power to pardon. I mean, it starts, of course, at some level with our ancients. The ancient Greeks and Romans had the concept of mercy in their law, where lives would be spared that were otherwise going to be taken. And that concept of mercy first sort of took root in the lineage, the common law lineage in some level, or the Western lineage that the United States law is built on, tracing back to England. It sort of took root with the English prerogative of the kings. And this was set in the legal codes after the Norman conquest of England in 1066 by William the Conqueror, that the codes that were passed and enacted as sort of the king's law actually provided the king with this power to issue pardons. As the centuries went forward for the British, there were struggles with the rise of Parliament and the battle between the Parliament and the monarchy, and it sort of came to a head in the time of Henry VIII, where this power of clemency Parliament tried to take for itself. The effort failed, and it was left entirely to the king. So by the time the sort of 17th century rolled around, at least in England, the king's power for pardon was absolute, and that really sets the stage for the development of the pardon power, of course, in the colonies on our continent, in our nation. And so during the period of the Articles of Confederation, the various state constitutions that existed, they actually conferred pardoning powers of varying scope and degree on the respective governors of those states within those state constitutions. But as the Articles of Confederation then were put forward, neither the New Jersey Plan nor the Virginia Plan, which of course were the two major competing plans at the Constitutional Convention for ultimately the Constitution and its vision, Neither of those plans included any kind of federal pardon power for the chief executive of the United States. And so it was sort of still at that phase something that resided within the states at the state level for pardoning of state offenses. Now, on May 29th, 1787, at the Constitutional Convention, Alexander Hamilton and Charles Pinckney introduced a specific proposal, and that was to give the chief executive of the United States the same pardon power that was enjoyed essentially by the British monarchs. That is, complete power. Now, the exception written in was with the exception of impeachment. So that pardon power clause that was proposed, it wasn't modified in any way, and it was simply adopted as it ultimately became within our Constitution that you saw in that earlier slide. It was proposed, adopted, and the rest, as they say, is history. Now, before we leap forward, we should pause to look at the history of how it was discussed, for example, in the Federalist Papers, because this sheds and casts a long shadow, really. It sheds a lot of light on how the pardon power and how the clause is interpreted in the modern age today. So, the Federalist number 74, as you see here, you have Alexander Hamilton saying, quote, "Humanity and good policy require the benign prerogative of pardoning. He saw this as necessary to mitigate the harsh justice of the criminal code, and the pardon power would provide for, quote, exceptions in favor of unfortunate guilt," end quote. Another quote from Alexander Hamilton is that, quote, "In seasons of insurrection or rebellion, there are often critical moments when a well-timed offer of pardon to the insurgents or rebels may restore the tranquility of the Commonwealth, and which, if suffered to pass unimproved, it may never be possible afterwards to recall." That's a very important policy and substantive concept of when and how the pardon power may be used in times of great unrest in order to bring a rapid and fast peace upon a disintegrating situation. And we'll see how that has echoed through the ages and actually been an example of when the pardoning power has been used subsequently. Now, at the time this pardon power was proposed in 1787, George Mason, one of the founding fathers, of course, who was very, very involved in the whole process, was very much opposed to the adoption of the pardon power because he believed it could ultimately be used by the president, by the executive, to create a near monarchy and to get rid of all political dissent. And the response came from Madison, James Madison, and that was that the impeachment potential that exists in that exception transcended any pardon power. And this was a very, very important concept and an early example of the separation of powers at work and how that impeachment exception to the pardon power clause really was seen as fulfilling a separation of powers function such that as awesome and broad a power as it may be in the hands of the executive to issue pardons, the people always had the power of impeachment that transcended that if the executive abused that pardon power. And that, of course, also forms part of the historical bedrock and then has sent a long shadow through history that we will see in terms of how that pardon power can be used. So this brings us back to the next slide. Our pardon power is incorporated into the Constitution in Article 2, Section 2. And as we look at that language, we see that it really is one of the least limited executive powers. And there's really only three limitations that leap out clearly from this language. One is that it is applicable to offenses against the United States. What that means, of course, is that it doesn't apply to offenses against the state, such as state claims. The president may not pardon someone for violating a California penal code, only a federal penal code. And nor does it apply to civil disputes between civil litigants. So it's limited to pardoning offenses against the United States. The other limitation, of course, is the massive facial one. It does not apply in cases of impeachment. And there's also an implicit time-based limitation that you can see in the language, and that is it may pardon, quote, offenses against the United States. That, of course, is a temporal type of limitation, which means the pardoning power extends to the pardoning of completed acts. In other words, the crime must precede the pardon as opposed to the pardon preceding the crime. Put simply, the president can't give you a blank check to go out and violate the law willy-nilly and run around like an anarchist. So the pardoning power really is limited to the pardoning of historical acts. The other textual question as we get to the next slide that we see is we have to address what's the difference between a pardon and a reprieve. There's clearly a textual difference between the two because the president possesses the power to grant reprieves and pardons. Now, a pardon in general wipes out the legal effects of a conviction. It can be granted from the time an offense is committed and can be issued after service of the sentence for that offense. But it cannot be granted before an offense has been committed. A reprieve, in contrast, is the commutation or the lessening of an existing sentence. It does not affect the legal guilt of a person. It could be, for example, a permanent reduction of a sentence, or it could be a temporary one. It could be a whole reduction or a limited one. It can take on varying forms, and we will look at some examples. One of the earliest then uses of this pardon power was by George Washington during the Whiskey Rebellion, during his term as president, his first term, when those who rebelled against this first federal alcohol-based law, the whiskey tax, effectively challenged this new government here in the United States. And there was this sort of rebellion and uprising known as the Whiskey Rebellion. And ultimately, the rebellion was quashed by federal agents. And George Washington then wisely used this pardon power to put back a forced peace and get rid of the dissent that existed in this nascent nation. And that's sort of the very substantive nature of the pardoning power that we saw Alexander Hamilton talking about in the Federalist Papers. And that's one of the earliest, of course, examples of the use of the pardon power. This brings us to the seminal case of Ex parte Garland. It's reported at 71 U.S. 333, and it's reported from 1866 from the U.S. Supreme Court. And this really is the most significant pardon power case in Supreme Court history that has really set the stage for all subsequent pardon power cases and has really become sort of the footing of the understanding of and the scope of the pardon power today. And we will see how it's created tension even with decisions today in terms of how courts have pushed up against some of the lines from Ex parte Garland. So let's start with the beginning, and that's what happened in Ex parte Garland. Well, Garland was a lawyer, and he participated in the Confederate Rebellion during the Civil War. He was a member of the Confederate Congress, and he was in the Confederate Congress from 1861 through the end of the Civil War. And he had been a lawyer before he was a member of the Confederate Congress. And then in July of 1865, he was pardoned for all offenses that he may have committed during the Civil War, along with many pardons, obviously, that were issued at the time in order to restore peace and tranquility as the country healed after the Civil War. So Mr. Garland wanted to go resume his practice of law because he no longer was earning money as a Confederate congressman, and that oath required him to say that he had never voluntarily helped anyone against the United States. And that was a requirement of the state oath for the state he was practicing in. And he couldn't swear to that because he had been a member of the Confederate Congress. And so he was unable then to resume the practice of law. So he argued that he was pardoned. And the effect of that pardon should be that he did not have to swear such an oath, or that he could swear an oath because he had been pardoned, and that he could resume his legal practice. That there was, in other words, the pardon wiped out the conduct such that he could legitimately swear the oath. All right, so we get to the next slide and we can see the rule that was adopted by Ex parte Garland. And this language, I quoted a lot of it because it really is very important language that defines the sort of contours and the metes and bounds, so to speak, of what it means to be pardoned, at least in 1866 when the Supreme Court wrote this. And we'll see how some of this language gets tested by more modern courts in terms of their understanding of what it means. So the rule is, quote, if granted before conviction, It prevents any of the penalties and disabilities consequent upon conviction from attaching. If granted after conviction, it removes the penalties and disabilities and restores him to all his civil rights. It makes him, as it were, a new man and gives him a new credit and capacity. A pardon reaches both the punishment prescribed for the offense and the guilt of the offender, so that in the eye of the law, the offender is as innocent as if he had never committed the offense. You can see that's really broad language and a very, very broad and expansive interpretation of what it means to be pardoned. It really comes up close to the line of sort of the idea of it being literally erased from existence factually, as if nothing ever happened. And it's echoes of that you can see in the language of new man and new credit. Now, a limitation that the court spoke about is that it doesn't restore any offices that may have been forfeited, civil offices that is, and it doesn't restore any property or interests that may have vested in others as a result of the conviction and judgment. So if someone was convicted of stealing money from someone and the money had to be repaid to the person, and it was repaid to the person, the defendant's then pardoned, it doesn't allow the pardonee to go back to the original victim and recoup the money that was paid in penalty of the crime. Now, courts have held, however, that criminal fines paid to the state, to the federal government that is, may be recouped by one once they've been pardoned. And so then, as a result of this rule of law, this holding, this concept of pardoned, the ex parte Garland Supreme Court concluded that that bar rule could not in any way prevent Mr. Garland from practicing law, and any such interpretation or punishment that thwarted his ability to practice law absolutely violated the scope of the pardon, and so he was able to swear his oath and resume the practice of law. Now, that was 1866. Let's fast forward a little bit, and we will see what happens when the Securities and Exchange Commission goes after you and you get convicted and then pardoned. This case comes out of New York in 2006. It's called the Securities and Exchange Commission versus Lewis. It's at 423 F sup 2nd 337. And the facts are as follows. In 1990, Lewis received a securities fraud criminal conviction. And part of the criminal punishment that the U.S. District Court issued was what's known as a bar order. And in security circles, that means the recipient is barred by order of the court here, at the urging of the SEC, from associating with any brokers or dealers in the financial world. Sort of the idea is to put a moat between the person and the financial world that the person had been operating in, where that behavior led to the conviction. So Lewis is now subject to this injunction as a result of his conviction, and he's precluded from operating in the securities industry. 2001 rolls around and he receives a pardon. And he then petitions the Securities and Exchange Commission to vacate the injunction to allow him to get back into the business of interacting with brokers and dealers and people in the financial world. And the Securities and Exchange Commission denied it and said, no, the injunction and the bar order are more collateral civil things that we demand you be held to, and the pardon doesn't wipe them away. Well, this went to the district court, and the district court disagreed. The district court concluded that the punishment for the underlying crime included the actual injunction and bar order. Those were sort of accoutrements of the actual criminal punishment. And when the pardon was then issued, it wiped away the guilt for the crime. He was now pardoned of it, and so it necessarily had to also vacate the injunction and the bar order. And so, like Mr. Garland over a century earlier, who was able to resume the practice of law once pardoned, Mr. Lewis was able to resume the business of broker-dealer business in the securities realm once he had been pardoned of his original broker-dealer crime. This brings us to the next slide, which looks at the civil collateral consequences that may come from a crime and then being pardoned of the crime, and the difference between when one receives a pardon and gets everything wiped away such that they can resume business, and the line between that and civil forfeitures or civil punishments one may suffer as a result of the crime, even though the crime has been pardoned, and this line between how far a pardon reaches and how far it doesn't reach. This case is called Robertson versus Gibson. It's at 759 F. 3rd, 1351. It's from the Federal Circuit in 2015. And it has really a rather long history, and the facts go all the way back to the Vietnam War. And so this case involved a petitioner who, during the Vietnam War, went absent without leave. He was convicted and he received a bad conduct discharge for going AWOL. And eventually, as you may all recall from history, after the Vietnam War came to an end, President Jimmy Carter started a blanket clemency and pardoning program for all of those Vietnam War soldiers who had gone absent without leave, many of whom had left the country, obviously. And that was enacted in 1975. And so it required that for these former soldiers who went AWOL and were convicted, that they had to attend and receive a clemency discharge program. They had to do some service and whatnot, and then they could actually receive this discharge and pardon so that their conviction for going absent without leave was pardoned. And after the clemency program had run its course and the person had done all the required steps, a presidential pardon then attached. So, petitioner here had gone absent without leave during the Vietnam War, had returned and taken advantage of this clemency and pardon program, and had achieved his clemency and then secured the pardon by jumping through all the necessary hoops. Now, many years later, he proceeded to apply for benefits from the Veterans Administration, civil benefits, medical, etc., from the VA. And the VA has an internal set of civil, laws and structures that they follow in terms of deciding who of their former soldiers, their veterans, is eligible for benefits and who is not. And the litmus test that the VA uses for the decision as to who gets benefits and who does not is one that turns on the nature of the discharge from the armed services. Was it honorable or dishonorable? If it was an honorable discharge, you can get VA benefits. If it was a non-honorable discharge, a bad conduct discharge, in other words, you're denied benefits. And so the VA looked at his application and said, I see here that you went AWOL, that you were dishonorably discharged, you were pardoned of your crime, and so you could come back. But nonetheless, the fact of the matter remains you were dishonorably discharged, and the pardon didn't convert your dishonorable discharge into an honorable one. It may have vacated the criminal punishment that followed on to going AWOL, but the discharge remains dishonorable, and so benefits were denied. The case was taken up then to the Federal Circuit, and the reason it went to the Federal Circuit is because the Federal Circuit in Washington, D.C. hears, of course, not only all patent disputes coming from all over the United States, but also all agency disputes from the Veterans Association. So it then receives this challenge to the denial of benefits, and it concluded that the VA properly handled the case, and that in order to secure and achieve these civil benefits of VA benefits, that one had to have a non-dishonorable discharge as a matter of fact. And that scheme from the VA was completely legitimate to demand as a factual matter that the discharge be, honorable or non-dishonorable. And the court concluded that although the pardon is extremely broad, under Garland it makes a man a new man and a new credit, and it wipes away his guilt for the crime, the court concluded the wiping away of the guilt for the crime didn't convert the underlying factual behavior suddenly into honorable behavior such that one could receive benefits. And the VA had the right to set up its civil scheme and its civil benefits law in a way that hinged on what's the nature of the discharge, and the pardon couldn't reach far enough to render his discharge non-dishonorable such that he could get benefits, and so it affirmed and benefits were denied. So that's an example of where you start seeing the reach of this new man, new credit idea, as if everything has been extinguished and vacated, really being tested, because one then enters a civil regime that has a different standard that has to be assessed, And the VA is not required from a civil perspective to stick its head in the sand and ignore what was the factual basis of the discharge. As a result, we can now get to the next slide, and we can see some general rules that follow from this pardon power that we now have, that the president has. The president may pardon federal crimes, not state crimes, and not civil violations or civil liability for acts. A president can issue a pardon for past actions, but not for future actions. There's no right to give someone a blank check to violate the law. The president can pardon someone preemptively for past actions even if there's no charge pending, and we will talk in more detail about preemptive pardoning. The pardon power is not applicable to any impeachment proceedings. The pardon power restores civil and political rights that may have been lost due to the conviction, but does not eliminate the crime from any subsequent factual analysis that may render past behavior relevant. And that's where you start testing the line of new man, new credit. So, the resulting textual question this raises that we're now going to get to is self-pardoning. Can the president pardon him or herself? Let's take a look at this. We're going to start with President Nixon as our case study for self-pardoning. There's a picture of President Nixon answering some press questions, and the reason that we're going to start with President Nixon is because it turns out President Nixon actually was the first president to ask the Department of Justice to look into whether the president can pardon himself from any offenses against the United States. So let's look at self-pardoning, and let's start parsing and asking the question of whether a president can self-pardon him or herself. We can start with the textual language. Number one, there is no express textual limitation on it. The language is incredibly broad, as we saw on the pardoning power, and it doesn't limit the president's power to pardon himself, as if the president can only pardon third parties. The one exception in the language arguably does textually imply that he could self-pardon if he wanted, just not to avoid impeachment. So in other words, the impeachment exception implies the self-pardoning power may exist for other offenses and crimes, just not to get oneself out of impeachment. And on the other hand, one could look at the structural language, the textual language, and say structurally, it implies a grantor and a grantee, a giver and a recipient. And it's very hard to look in the mirror and say, I pardon you, right? I mean, that textually is at odds at some level with the language, which structurally implies two different people as opposed to one person. That is a long way of saying the textual language is unclear. It hasn't been litigated and tested as to the self-pardon power, and legal scholars and legal academics all are all over the map and disagree as to whether the president possesses this self-pardon power. It's just in the eye of the beholder, I guess, until it gets tested in court as to whether the textual language allows it or doesn't. The framer's intent is also somewhat unclear about this self-pardoning question, and it is not really directly discussed. You have James Wilson at the Constitutional Convention said, if the president be himself a party to the guilt, he can be impeached and prosecuted, again echoing this capacity to impeach him for the crime that he committed, even if he doesn't get convicted in a criminal court of the crime he committed, because maybe he pardons himself. Judge Posner has written that from his perspective and interpretation, given the breadth of the constitutional language and this power, the president indeed could pardon himself. And then we get to the pardon attorneys at the Department of Justice. And the pardon attorneys at the Department of Justice have concluded that, in theory, the president certainly could self-pardon, but then he would be potentially subject to impeachment for doing that. That's one interpretation from one pardon attorney. Now, however, let's get to President Nixon, because President Nixon, at the height of the Watergate problems he was confronting, actually reached out to the Department of Justice, the Office of the Pardon Attorney, and asked them to analyze the question whether he could pardon himself. And as we see on the next slide, he got a memo back from the legal counsel at the Department of Justice on August 5th, 1974, and I don't remember the exact date, but if you Google right now while you're listening to this when President Nixon resigned, it was very short, very close on the heels of August 5th, 74. The advice he got back was that under the fundamental rule that no one may be a judge in his own case, the president cannot pardon himself. This fundamental rule comes from this sort of natural law concept that one can't be a judge of his or her own case, and so therefore the presidential pardon power should be interpreted in accord with those natural law precepts to conclude that the president lacks the pardon power. Now, the Department of Justice lawyers did offer President Nixon kind of a unique workaround to, in effect, get a self-pardon without even giving up the presidency. And part of what they concluded in their memo was the following. A different approach to the pardoning problem could be taken under Section 3 of the 25th Amendment. If the president declared that he was temporarily unable to perform the duties, then the vice president would become the acting president. And as such, the vice president, now the president, could pardon the infirm president, who would then subsequently recover from his infirmity and resume the duties of his office, now cleansed and pardoned by the vice president who had been the president temporarily, or entirely resign and get the benefit of a pardon too. President Nixon obviously opted for at least one of those routes and not the other. He didn't declare himself infirm under the 25th Amendment. He just resigned, and then eventually, of course, a pardon flowed from President Ford. The current legal thinking, when one surveys and canvasses legal scholars who've written on self-pardoning power, is that most legal scholars tend to agree with the Department of Justice that the clause read in its structural sense of requiring two people, the pardoner and the pardonee, and in light of the natural law precept that sort of inhabits the entire and animates the entirety of our constitutional and our legal heritage, about no man being a judge in his own case, all militate in favor of an interpretation that if pushed on the courts should ultimately conclude that the president lacks the self-pardon power. But again, it's untested, and it has never been tested. The next slide actually asks a very interesting question, which is, if a president was to ever self-pardon him or herself, what kind of a boomerang could this create? And so imagine, if a president's running along and decides to issue a self-pardon to himself to put an end to investigations and the like that may be percolating around there in grand juries or special investigators or whatnot, depending upon the nature of the underlying charges, it's entirely possible that that issuance of a pardon would now become very powerful evidence that could be used by a state attorney general to bring a state charge against the president. And that pardon would be a concession, in effect, of guilt. It would go a long way to actually proving guilt of the crime if one pardoned him or herself of a specific set of of behaviors that were leading to an investigation, where there's an overlap between the federal and the state laws, which often happens, of course, when one thinks of sort of financial crimes and whatnot that trigger the U.S. codes, but also, New York state codes and California codes and whatnot. So it could be a brutal boomerang and a very, very dangerous thing for a president to actually self-pardon and then find himself the recipient, or herself the recipient, of a state conviction with a strong prima facie evidence of guilt coming from the pardon. And of course, self-pardoning could certainly trigger impeachment proceedings if the clause is then triggered by the powers that be in the House and the Senate for exceeding, and abusing one's powers and privileges as president by pardoning themselves out of the underlying crimes. So it may work if the courts upheld it, but one may still find themselves impeached and out of a job and potentially in trouble with the states. This brings us to our preemptive pardoning question that we talked about earlier, and this gets back, it keeps us on President Nixon, and our case study now is part 2 of this case study of President Nixon. And a preemptive pardon is a very, very rare pardon. A preemptive pardon is where there is not a pending charge. There's been no indictment, there's been not even a grand jury impaneled necessarily, but certainly no indictment, no criminal complaint filed. And so there is no actual charge and target that's been set up by the prosecuting authorities. But nonetheless, there's been a historical set of conduct which could lead to a charge, and a pardon is then issued before any charge or indictment is brought. That's known as a preemptive pardon. It preempts the indictment or the criminal complaint, but it does append to historical conduct. And as we see here, this is the proclamation of pardon from Gerald Ford to President Nixon, and it's your classic, typical form of preemptive pardon, where there had been no indictment or criminal charge filed against President Nixon, but nonetheless, he was pardoned from all offenses against the United States from which he has committed or may have committed or taken part in during the period of January 20, 1969 through August 9, 1974. This brings us to the preemptive pardon, which was challenged in court immediately after President Ford issued former President Nixon the pardon. And so what happened is a lawyer filed a debt relief action arguing that the pardon's void because it was preemptive. And the argument was that up to that point in time in history, the pardoning power had attached primarily to indicted crimes or charged crimes, and so it should be interpreted to preclude preemptive pardoning and should require the indictment of the president before the pardon is to be issued. And it's a very, very interesting case because you see the court stating the context in which this decision and this battle has now erupted. And the court's contextualizing of the history of where the country was in 1975 is really important. And the court says, quote, "When Mr. Ford became president, the executive branch was foundering in the wreckage of Watergate, and the country was in the grips of an apparently uncontrollable inflationary spiral and an energy crisis of unprecedented proportions." In other words, here we have an example of a federal judge talking in the terms that Alexander Hamilton in the Federalist Papers was talking about, which is in times of great crisis when the nation's being torn apart, the pardoning power can be very important to help establish some tranquility and bring peace and get the country moving again. And so the court then held that the fact that President Nixon had been neither indicted nor convicted of an offense against the United States didn't affect the validity of the pardon. And indeed, by pardoning Richard Nixon, who many believed was the leader of a conspiratorial insurrection and rebellion against American liberty and constitutional government, President Ford was taking steps, in the words of Alexander Hamilton in the Federalist, to restore the tranquility of the Commonwealth by a well-timed offer of pardon. Those are the words of the federal judge in the District of Columbia in 1975. And so the case was dismissed, and it affirmed the continuing vitality of the idea of a preemptive pardon and the substantive timing and nature of when preemptive pardons are actually issued by presidents to help restore some peace and get the country moving again. The case was dismissed. And so on the next slide, you can see the result, of course, is that a preemptive pardon rule is simple. It's a pardon for crimes that one may have historically committed or actions which could be deemed criminal, but for which no charges have been filed or brought. They can receive a pardon. It's known as a preemptive pardon. And there, again, we have a copy of the actual pardon issued by President Ford. As we see on the next slide here, preemptive pardoning indeed is very, very rare. It's generally used in highly publicized political type cases as opposed to the run-of-the-mill pardon request by those who've been convicted of crimes. But again, it's a testament to the awesomely broad power that exists. One example of preemptive pardoning on a massive scale is, of course, the issue we discussed about earlier, which is President Carter's pardoning of the Vietnam draft dodgers and those who went AWOL. And it ultimately was a blanket amnesty program in effect for hundreds or thousands of possible people who returned, affirmed allegiance to the U.S. and did 2 years of public service work. Another example of preemptive pardoning, as well, of course, as President Ford's preemptive pardoning of President Nixon. Another one from slightly more recent times, this brings us to the 1980s and the early 1990s, is the Iran-Contra situation. And you all remember Iran-Contra from the news in terms of the triangle of dealings between the United States and Iran and the Contras down in South America, and arms and guns and money and all that stuff flowing around, all of which became highly publicized hearings with Oliver North in the 1980s, and that was sort of the 80s version of Watergate almost, right, with sort of great journalistic excitement and fervor about this scandal of sorts. And so Iran-Contra ran its course, of course, and folks were convicted and whatnot. And several people were actually convicted of crimes and were sent to prison, and others were awaiting trial. And so ultimately, President Bush in 1992 pardoned former Defense Secretary Caspar Weinberger and former CIA official Duane Claridge right before they were to be tried on federal criminal charges for their role in the Iran-Contra affair. And that, I think, if I remember, literally came like on Christmas Eve. It was sort of a Christmas present, a mere 5 or 10 days before their trials were set to begin. And so for them, it's an example of, again, a preemptive pardon before prosecution is set to begin, but after the alleged conduct has occurred, and designed to put to rest a national controversy and set of issues that have animated and caused great divisiveness in society, and just get back to the business of running the country. And that was sort of that kind of theory behind it is what stood. At the same time, there was also a traditional pardon issued for those in the Iran-Contra for people who had been convicted of various felonies and misdemeanors and had already been sentenced. And here you have Claire George of the CIA, Alan Fears of the CIA, Elliot Abrams of the CIA, and Robert McFarlane of the NSA, all of whom had been convicted and were sentenced, and they received a pardon the same day by President George H.W. Bush. And the statement issued at the time by the president was that the common denominator of their motivation, whether their actions were right or wrong, was patriotism. And that concept, again, sort of harkens back to what we saw in the Federalist Papers from Alexander Hamilton about his concept of needing it in times of what he called or phrased unfortunate guilt, which perhaps is a very similar way of saying what President Bush here said, which is guilt exists, but it's unfortunate perhaps because their motivation was placed in the right place, or some theory like that. In any event, but that's the theory that exists within pardon law, and the president has this awesome power to adopt and use. This brings us to the Jimmy Hoffa case and the issue of being careful what you ask for. Here, the issue that we're going to start talking about is the ability of someone to receive a pardon, take the pardon, and then be unhappy with the terms of the pardon and reject the pardon to try to get out of it. In other words, can you take the good but not the bad, or do you have to take it all together like a bitter medicine? So the facts were as follows. Jimmy Hoffa was convicted of jury tampering in federal court, and this led to a 15-year federal sentence that he was then serving. Jimmy Hoffa petitioned President Nixon and asked for a pardon. And President Nixon then, in 1971, while Hoffa was in federal prison, issued a pardon. But he issued the pardon with a condition. The condition was that Hoffa, quote, not engage in any direct or indirect management of any labor organization until 1980. Now, Jimmy Hoffa had already served several years of his sentence. He's in sort of 1971 or 2 here. He was set to be released in 1975, and he receives this pardon then where he's got 3 years left on his federal criminal sentence. He takes the pardon, but he's out of the union business until 1980. If he didn't take the pardon, he would stay in prison till 75, but in 1975 he could jump back into union business. Jimmy Hoffa took the pardon, jumped out of federal prison. He's then unhappy. He wants to get back in union business, right away and not have to wait until 1980. And so he filed a lawsuit challenging the condition of his pardon. And on the next slide, as we can see, the case is entitled Hoffa versus Saxby, 378 F. Sup. 1221, and it's reported out of the District of Columbia in 1974. Jimmy Hoffa's argument is outlined here, and it's as follows. His position was that the condition prohibiting him from participating in union management until 1980 was an unlawful infringement on his First Amendment rights of speech and association, to associate with and participate in union business, to proselytize and argue for the rights of his union and workers, and that ultimately amounted to an additional punishment on him from 75 to 80 that contravened double jeopardy principles also, and then also violated his Fifth Amendment due process rights. And it was a term of punishment that sort of is an accoutrement of being punished in a prison setting that was now being issued by a president not by the judge in the federal criminal court where these types of sentences are issued. And he argued he never accepted the condition because no one ever told him that condition was on there. He just got released from prison, in effect, is what Jimmy Hoffa's argument was. Well, let's see on the next slide how the court took that. The court concluded that to deny the president the flexibility to come up with conditions that would result in this situation is simply something that Jimmy Hoffa couldn't proffer. And so the court concluded that the history and nature of the pardoning power has always contemplated that the president has incredibly broad discretion that lets him put on bells and whistles, right, to this issuance of a pardon. And conditions and terms that the person is given that they can accept, or they can say they don't want it and they can stay in prison and not get any of it. And so in other words, what the court concluded is the power to pardon is not like a light switch. It's not a power where the president can either turn it on and just someone gets out and that's all the president can do, or turn it off and no one gets out and no one gets a pardon. The president can say you're being pardoned, but there are these terms and conditions I'm going to stick on it. And the court concluded this is especially so where the terms and conditions are comparable to the exact types of terms and conditions that often accompany sentences, such as being prohibited from participating in certain industries, like in the SEC case we saw earlier, the bar order about participating in the securities industry. Typical order here would be for Hoffa, given his jury tampering in relation to the union challenges and allegations against him, it was legitimate to have a bar order from that industry. And so the court concluded that the pardon condition was fully enforceable. Hoffa, the court said, could have rejected the pardon entirely and stayed in prison, but the court noted he didn't, and he hasn't actually gone back to the prison and knocked on the door and asked to be put back in prison. What he really wanted was to get out of prison, but also get back into union business and take the good, not the bad. And so the court ultimately concluded that it was a legitimate condition that President Nixon could place on Hoffa's pardon, and Hoffa's case was dismissed. Now the question this raises, though, is it really the case that Jimmy Hoffa could have undone the deal in some way by actually going back to jail, knocking on the door and saying, hey, put me back in, I want to finish the rest of my term, and so that I can then get out in 75 and I can then get back into union business before 1980? The answer is actually probably not. Once you've accepted a pardon deal, it really, under the law, it appears, it's done. There is no way to revisit, to rescind, to re-argue, or relitigate the issuance of that pardon by the president. One famous case here that goes even further than that principle, I said, is Perovich versus United States. It's a U.S. Supreme Court from 1907 at 205 U.S. 86. And there the facts are as follows. Perovich received a death sentence in U.S. District Court, federal death sentence. President Taft commuted it to life in 1909, life in prison. In 1925, Petrovich files a petition saying the pardon's improper, given it changed the punishment only, and so it was a conditional pardon, and he'd rather now revert to the death sentence. In other words, the prisoner, sort of 16 years later, said, I don't want to be in prison the rest of my life, just give me the death sentence, I want to go back. And this was some sort of a conditional pardon that should be unconstitutional. The district court actually agreed with the prisoner and issued a habeas petition basically saying President Taft's pardon order was unconstitutional and invalid, and thus the death sentence and death penalty should be reinstated on Mr. Perovich. Now, this made its way up to the U.S. Supreme Court, and in a very famous opinion written by Justice Holmes, it was reversed. And Justice Holmes concluded that, and this is an important modern take on the pardon power, that the presidential pardon power is actually part of the structural framework of our system, our separation of powers, our Constitution, of the executive. And so the president gets to decide ultimately what is best for the public at some level in these pardon decisions. And the public welfare is part of that animating calculus, and the recipient thus can't reject it. So the result of this is that the president in that case and in subsequent cases has been able to commute sentences from death to life and the person can do nothing about it. That's sort of the most extreme example of where the president can pardon someone despite their request even, and terminate a death sentence and give someone life in prison instead, as part of this public welfare concept that Justice Holmes talked about, which is yet again a new wrinkle on the pardon power, because it goes beyond just a private kind of transaction between the president and the recipient and the president's personal, like king-like calculus as to what's right or wrong. But it's now a decision that's imbued with and animated by broader public welfare concerns. That means the president, in exercising that discretion and function, is able to do things that even maybe perhaps the recipient of the pardon isn't excited about and doesn't want. There's another famous example that did not make its way into the annals of the case law, but it did make its way into the history books, and that involves President Coolidge, who pardoned a prisoner, and this prisoner who was pardoned actually wanted to stay in prison and refused to leave prison. And it created a bit of a controversy, and President Coolidge issued a stern warning to the warden of the prison that the warden was to remove the prisoner and lock the gates behind him, which is a hilarious new take on prison gates and prisoners. Normally, gates are being locked the other way, but here they were locked on the way out, and the prisoner was not allowed back in. The prisoner, turned out, was apparently sufficiently happy at his newfound freedom that he didn't actually litigate the case to find out whether President Coolidge's capacity to do that was lawful. This brings us to the difference between commutation and pardon, and we can look at the more recent case coming out of the Wikileaks scandals and Chelsea Manning. And so here, let's briefly recap the Chelsea Manning story that all of you obviously probably are well aware of. But we have Manning, who's in the Army, who leaked thousands of secret war documents to the Wikileaks folks, who then published them. And Manning was then convicted under federal military law and received a 35-year sentence in the military brig. Now, the first point is that federal military convictions are offenses against the United States and are then within the jurisdiction, so to speak, of the presidential pardon power under Article 2, Clause 2. And so Manning issues or makes a pardon request of the president, and President Obama decided not to pardon Manning, but instead to issue a sentence commutation, which in effect is a form of reprieve. And so Manning's sentence was commuted to all but 4 months of the sentence, so that by the time Manning was released, Manning had served 7 years total. And the rationale for issuing a commutation instead of a pardon, as issued by the presidents historically, is that it's for where you have cases of acceptance of responsibility that President Obama found Manning had, where there's a disproportionate sentence to comparable leak cases, which President Obama found Manning had, but where nonetheless still the conduct was illegal and wrong, and so wasn't worthy of a full pardon. And so Manning then ultimately received a commutation of the sentence for the Wikileaks leaks and got out of prison. So this gets to the difference between commutation and pardon. And commutation is obviously a form of executive clemency, but it doesn't have the same legal effect as a pardon. The commutation only reduces an outstanding or extant sentence by some amount, all of the sentence, a small amount, some of it. But it doesn't change the fact of the conviction. A commutation doesn't imply innocence, and it doesn't remove any civil disabilities that may apply to the convicted person as a result of the criminal conviction. So the difference being President Nixon was pardoned, and meaning that the pardon is so broad that one can go serve on a jury duty and one can hold office and other things. But Manning, on the other hand, of course also being different, that Manning had actually been convicted, unlike President Nixon. But Manning receiving a commutation instead of a pardon means Manning doesn't get to vote and sit on a jury, and other civil disabilities that flow from the fact of conviction still exist for Manning. The next slide shows the real breadth of a pardon then in distinction to commutations, because a pardon ultimately is an expression of the president's forgiveness, and it's granted in recognition of this deep acceptance of responsibility, good conduct, and although it doesn't signify innocence per se necessarily, although it may, and many pardons have been issued for people who the executive has concluded are ultimately innocent, it does remove civil disabilities, such as the restriction on the right to vote, hold state or local office, or sit on a jury, which flow from convictions. And so ultimately, pardons really should also lessen the stigma that arises from convictions. Our next slide looks at posthumous pardons, and posthumous pardons have been issued historically. President Ford issued one in 1975 to General Robert Lee. President Clinton in 1999 issued one to Lieutenant Henry Flipper at the request of his descendants, because Henry Flipper was the first African-American cadet from West Point. He was dishonorably discharged from the Army in 1881 in very unfair and improper circumstances, and President Clinton issued a posthumous pardon for Lieutenant Henry Flipper. President Bush in 2008 issued one to Charles Winters, who had been convicted of smuggling bombers to to Israel in the nascent stages of Israel's formation. And then also at the state level, states have state constitutions, of course, and state executives, governors, and states all have varying pardoning powers for state governors. And many state governors have issued posthumous pardons to death sentence recipients who had received, obviously, the death sentence in decades earlier, and who now it's been concluded were actually innocent, or factually innocent perhaps, and then others who have received posthumous pardons. There is a federal administrative process for administering the pardoning power. It's been set up by executive order from 1893, and it's now run by the Department of Justice. So if you have a client who wants to get a pardon for something, there's actually a detailed legal regulatory regime and a set of hurdles that you have to jump through as a lawyer representing your client to try to get them a pardon. And you can find this in the Code of Federal Regulations at 28 CFR sections 1.1. And it sort of walks you through the process of how you petition to pardon or seek sentence reduction for one of your clients. And I have the website listed there for you if you want to go look at it in more detail. On the next slide, I have kind of the most important factors that the Office of the Pardon Attorney working with the President looks at when considering prospective applicants for a pardon. You need to have waited 5 years post-conviction, and then certain guideposts are important. There's been post-conviction conduct, character, and reputation that's sterling and shows genuine acceptance of responsibility. The seriousness and relative recentness of the offense is looked at. Changing mores can have a big impact, like obviously the shifting nature of medical marijuana, or marijuana, for example, under state law and prior federal convictions for marijuana. Acceptance of responsibility, remorse, atonement. The need for relief is another factor that the executive looks at. And then official recommendations and reports from state agencies, physicians, doctors, counselors, priests, etc. This brings us to a series of myths that come up in terms of presidential pardoning power, and we're now going to look at a few myths as we bring to a close this Curious Lawyer program on the presidential pardon power. Myth number 1, if a pardonee reoffends, the sentencing court the second time cannot take into account the previously pardoned crime. It's a myth. Actually, the way the law works is if you've been convicted of a crime and you're pardoned, and then you reoffend, when you get sentenced for that new crime, the court can look at the pardoned crime and use that as a basis to enhance your sentence for the second crime. Now, you may listen to what I just said and say, that seems to run afoul of that new man, new credit thing from Ex parte Garland, and at some level it does really, because if the first one's been wiped away, when you're sentenced on the second conviction and the first conviction is used as an enhancement, you really do seem to be receiving a punishment for that first conviction. The courts and the sentencing guidelines have all found ways of saying that's not true, as you see here in these cases in the sentencing guidelines. And so the result is, prototypical case, is this one U.S. v. McMichael in 1970, convicted of a marijuana drug crime. 1977, he was pardoned. In 2004, he again was convicted of federal marijuana conspiracy crimes. And the court in 2004 was able to look at that 1970 pardoned marijuana conviction to enhance the sentence for the 2004 crime. One way perhaps of looking at this is one should not look a gift horse in the mouth. If you're pardoned for a federal drug crime, find a new line of business. That seems to be the adage, that you shouldn't look a gift horse in the mouth. It seems to be animating the courts. But in any event, that's myth number 1. Myth number 2, as we see now, is that if you are a disbarred attorney, or you're perhaps representing a disbarred attorney, and you receive a pardon from the president, or perhaps a state governor, you can, as a matter of course, reapply to the bar and be readmitted. It turns out, no, you can't, as a matter of course, automatically be readmitted. Now, although you're not automatically entitled, the law really across all jurisdictions when you survey it is that although it's not automatic, it's heavily in your favor that you're likely to get back in the doors of the bar and become a lawyer. So the lawyer seeking reinstatement has this burden in the civil system to show that they are of good moral character, and the existence of a pardon goes a long way, the decisions have said, to showing that a convicted federal felon, or if it's occurring on the state side, a state felon with the state pardon, in any event, the pardon goes a long way to showing that they are of good private and professional character. And so in pretty much all the cases that you canvass, you find that a formerly disbarred attorney who's now been pardoned tends to be able to get back into the admission of the practice of law. The final myth is myth number 3. A pardon erases the conviction, so that when I'm asked on a job application if I've ever had any prior convictions, I can say none. Turns out that too is a myth. Under the federal provisions in law from the Office of Pardon Attorney, and the state provisions are the same in most states, if you're a recipient, a grantee of a pardon, you do actually still need to continue to disclose the existence of the conviction on any application forms where it's asked for, but you may also note that you've been the recipient of a pardon, and those are the regulations in law. So that's our walk today through the presidential pardon power and its awesome limits, as we've touched upon Jimmy Hoffa, President Nixon, President Carter, and the Vietnam draft dodgers, and Iran Contra, and even the Wikileaks and Chelsea Manning story. I hope you've enjoyed this walk through this unique and different area of law, and join us as we explore other fascinating, fun areas of law in the Curious Lawyer series. Thank you.